evening, ladies and gentlemen. Welcome to the first Brodies Environmental Law Lecture Series of 2018-19. For those of you who are new to the Brodies Environmental Law Lectures, these have actually been going since 1993, and probably not done thorough research, but I think we'd guess that this is probably one of the longest running environmental lecture series in the UK at least. And we have been welcoming academic experts, practitioners, judges, government officials for a number of years now to share their thoughts about some of the pressing environmental issues of the day and how the law relates to those. Come in, don't be shy. Looking through the list of previous lectures, actually, I was surprised to see that I think this is the first one that has been explicitly about air pollution. But it's clearly a topic that is of pressing importance today, so I'm very pleased that we finally took this one off the list of the Brodies series, and it's a great pleasure to welcome Dr. Daphina. I'm going to get this wrong, but I'm going to try Misiedjan from the University of Utrecht. And Daphina was in Edinburgh about 6 months ago now at the Association of Human Rights Conference that was organised by my colleague, Dr. Nicole Smith, giving a presentation on a very similar topic, and I was so impressed that I went up to it at the end and I said, would you mind kind of developing this a bit more and coming to deliver it to a slightly different audience of environmental lawyers in the spring? And I'm pleased to say yes, and here she is. So Daphina will be presenting on the human rights-based approach to tackling air pollution. That's enough from me. I will hand over.
Thank you very much. Good evening, everyone. I'm excited to be here and to share with you some of my research in progress. So let's start off by a short exercise. Now, imagine yourself as a parent of 3 children. You have 2 boys and a girl. And your oldest girl is about 9 years old. And when she was born, she was a healthy young baby. But when she developed and became older, she started to develop asthma. And this became so severe that in 2011, her lung collapsed. And after that, she had 3 years of seizures, 3 years of agony, and it finally ended in her passing. Now, this is, of course, not an exciting exercise, but it's actually the story of Mrs. Kissy Deborah. She's the mother of Ella, and Ella is one of the children who has passed in 2013 as a result of asthma that she developed because of air pollution. This lady went on to research, and she found that between 10 to 15% of young people living in London who are younger than 19 have developed asthma as a result of air pollution. And that's, of course, not really surprising because big cities are actually hotspots for air pollution. So today I would like to take you on sort of a ride to see how we can tackle air pollution from a human rights-based perspective and whether or not we can see how human rights and environment can collide and hopefully bring a good solution to tackling this issue. So here also you see a picture of London with the areas where there's high air pollution. And her house was actually in that area. And that's why in her research she found that that is a cause of Ella's death. So today we'll be talking about air pollution and its effects. So I will talk a little bit about what are the causes of air pollution. I will talk about the current regulation that we have on air pollution and see whether or not human rights or human rights-based approach has any added value. So when we look at the sources of air pollution, we can see that we have different types of sources, and we also have to look at both indoor and outdoor pollution. When we look at indoor pollution, we can think about how people warm their houses, how they cook their foods, and how that is connected to, for instance, the use of coal or wood. When we look at outdoor, we can see how ineffective modes of transportation, but also coal-fired power plants pollute the air. And then we look at different air pollutants such as nitrogen oxides, sulfur oxides, particulate matter, and heavy metals such as mercury and lead. Now these have influenced our health, and it goes beyond what we normally think of. So normally when we think of air pollution and health, we think of lung disease, right? But we actually see that air pollution also affects, for instance, our heart. It is the cause of 25% of deaths related to heart disease, and it also relates to stroke. So air pollution is not only the cause of lung disease, but also many more other diseases that we can see. And we can see that globally, 7 million people in 2006 have passed away prematurely because of air pollution. And of those 7 million, we can see that 600,000 were children under the ages of 5. So air pollution is one of those issues that is sort of invisible, but it actually touches us all. And we can also say that even within the European context, they are estimating that we will probably also have a premature death 1 year earlier due to air pollution. So it's a very widespread problem. And when it relates to children, we can see that 9 out of 10 children worldwide do not breathe safe air. And this especially relates to those who live in the urban areas, because 80% of them are exposed to air pollution at the levels that exceed the WHO norms. So that's not really a positive picture. And what is also interesting is that we can talk about what it even makes worse. And that also starts with a question. Do you know at what point we are exposed to this air pollution? When does it start? No, it's okay. Sorry? In the womb. In the womb? Okay. Anyone else who says in the womb or somewhere else? Well, actually, you're correct. So it starts in the womb. So this is a research done or was published at the end of 2018, and it talks about how they found that the particulate matter actually attaches itself to the placenta when a woman is carrying a baby, and that can have, of course, adverse health risks. And it has also made that some people have actually lost their children due to miscarriages. And can someone notice where this study was done? Yeah, exactly. So this was in London. So this is not an issue of, let's say, the global south. This is an issue also that's very relevant here in Europe. So what can we do about it, or what is currently done about it when we look at the different air pollution regulations? So what we can see is that there's very much a fragmented situation when it comes to air pollution, also when it relates to transboundary air pollution. So we can see that different regions, for instance, have different instruments, but there's no global instrument that deals with air pollution. So here we have, for instance, the Convention on Transboundary Air Pollution. And often we don't think about transboundary air pollution because we think it's only a local issue. But when we look at this map, this is also research that has been published in 2018. It talks about how actually air pollution gets exported and how it actually goes beyond boundaries and can go beyond continents even. So here it shows that the West actually exports a lot of its air pollution towards the global South. And this is due to different types of winds. And as a result, a lot of deaths have been taking place in the global South because of this air pollution. When I first heard this, I thought, okay, that's very interesting. I wouldn't expect this because you think of it as a local issue. It's often framed as it being regional or local, but it's actually also a global issue. So if we don't have any instruments that talk about how to deal with air pollution at a global level, then we might not be as effective in tackling air pollution. So one of the other issues is the agreement on transboundary haze pollution. That is one agreement that has been made in the South Southeast Asian states, but it only deals with certain types of air pollution, and it started actually because of the acid rains of the 60s. And after that, it developed, and more issues of air pollution are being tackled by this instrument, but not enough to actually deal with all of the different pollutants that we have. Now, after this international perspective, we can also look at what type of international principles we have that could apply to air quality. Now, of course, we have the Trill Smelter arbitration. Who knows that one? Everyone, I hope. Because it's one of the best cases that we have, or actually where precedent was set on the non-harm principle. So this was a case between the US and Canada, and it concerned the smelter, of course. And the smoke was actually affecting beyond the border. So in this case, it was said that states should not harm each other, but it was seen in a local context. So it was only between the US and Canada. But now the question would be, does this also apply to long-distance air pollution? How do we deal with that? And of course, we also have the common but differentiated principle when it comes to the different responsibilities that states might have. And especially now with the energy transition, you can see that maybe this will also apply to air pollution, but how we will discuss in a little bit. And lastly, we have at the EU level different directives. So we have the directive on ambient air quality and cleaner air for Europe. We also have the directive, the NEC directive on national emission ceilings, and we have some source-specific legislation, and lastly, some case law. So I will go a little bit into how this directive, or what the directive looks like. So the directive has the overall purpose to define and establish objectives when it comes to ambient air quality, and it's meant to avoid and prevent and reduce harm to both humans and the environment. It requires that states actually draw and adopt different implementation mechanisms so that the national pollution can be controlled. And it requires also that different programs take place and also monitoring is done. Now, this directive is, of course, a very good first step, but I would like to see if you can notice something when we look at this. So here we have an overview of what the air quality directive says, but we also have the WHO guidelines when it comes to air quality. So those guidelines talk about what is harmful to our health, and they set certain boundaries. So what do you notice here? Sorry, I didn't know who that said. Oh, sorry. Yeah. So we can see, if we look at ozone, we can see a discrepancy between what the EU directive says and what the WHO says. What else do we see? What is interesting about this? Different timescales. So what happens is that we often look at the averages. So we set a boundary or a limit, and then we look at what is the average over time. And that is, of course, very interesting, because if you have certain spikes, what do you do with the spikes, right? So we take the average, but the spikes are also still harmful. So for instance, if you look at this is from the Netherlands, so sorry for the Dutch, but it's a meter that we have near our university, and it takes up and studies the different air pollutants. And what you see here is that we have a spike when there is traffic, right? When there's a lot of traffic, then we get a spike, and it almost comes to 75. So that would mean that the air quality is actually insufficient. But if we take this on average, then you see that the air quality is pretty okay, right? Because it meets that limit. So what do we do with those spikes? Because those spikes are the ones that actually affect our health pretty badly. But it's something that is kind of a challenge in the monitoring and in the enforcement. And that is also what relates to the story that I told in the beginning. Because Ella's mother is actually arguing that certain spikes have had an effect on her health and have, for instance, caused that she has flare-ups. So in that sense, we also need to look not only at the averages that we hold, but also at when are the spikes taking place and how do they affect our health. And we can see that states indeed have issues with trying to keep up with those air qualities or air quality standards. So for instance, in Brussels, we have Client Earth that is representing certain inhabitants, and they're going to the court or to the European Court now. We also see that the UK has failed with its air quality or keeping up with its air quality standards, and how will it go after Brexit? So you can see that states have had issues with keeping up with these standards. So what then happens is that these cases go to court. And I have some cases that I can discuss with you, some that have taken place at the European Court of Justice and some also at the European Court for Human Rights, but I will talk about that a little bit later. So the first case takes place in Germany, and it's a case about a German citizen named Yannick Kesch versus the Free State. So this is about him as a German citizen, and he actually noticed that locally there weren't any programs or no action plans to take on the air quality issues in his city of Munich. And in this case, it was actually said that citizens have the right or have standing to enforce limit values. So this was one of the first cases where that was decided. It means that citizens actually have a right to a legal remedy, and they can also request air quality plans, because Munich had no air quality plans, and he saw that there was definitely some air pollution that was affecting his health negatively. In a following case, it was also said that NGOs have the same standing. That was the Darmstadt case. So even NGOs can now go to the court and represent citizens in air pollution cases. Now, what is interesting about this case is that it basically broadens the standing requirements, and that it also looks at the scope of judicial review. Because what is often considered is that courts cannot look at what type of policies states have, but in this case they said, well, there need to be specific measures, and the court can even suggest specific measures, also to, for instance, make sure that they catch up to the deadline that the directive has, or even make sure that they meet the standards within the deadline or sooner even. So courts can also make certain suggestions now when it comes to these type of air pollution cases. Now the second case is here in the UK, and it concerned the UK government failure to produce also an air quality plan. Has anyone read this case? Yeah, okay. Then you can look it up. So it started off in 2011 when the High Court actually said that if they would have a mandatory order, if they would make the state have these air quality plans, then it would raise serious political and economic questions. And that is not up to the court. So the court basically said, it's not within my tasks, I'm not able to do this. The case proceeded to the UK Supreme Court, and there the court actually said that the UK was in breach of not living up to the standards that were meant in the Air Quality Directive, but it also referred the case to the ECJ, and the ECJ then said in its preliminary ruling that NGOs have standing, but also that the enforcement of the Air Quality Directive is the responsibility of national courts. So that means that we as citizens can indeed go to national courts and make sure that our states are living up to this directive. Now this of course builds on the case that we just discussed, and the ECJ also ruled that the limit values really in itself already impose an obligation to achieve the result. So member states are actually required to take measures. Now what we've seen so far is that there are certain cases that are connected to, of course, the directive. So they are not really based on human rights itself, but they are connected to the EU directive that we have. So what we're not going to do now is see if taking a human rights approach adds anything to that, if it is of added value. And what you see is that in general, the environment, or tackling on issues of the environment, are becoming more and more a human rights issue. It used to be two completely separate fields, and now they're coming together, which is also interesting and very logical, because it's an interesting strategy that you can take. So the first point, why it is good, or at least an interesting development, is that we can see that normally traditional human rights instruments don't really include anything specifically on the environment, right? They kind of assume that there is a conducive environment for all human rights, and they didn't really take that into consideration. But the environment is, of course, a prerequisite for the enjoyment of human rights. So in that sense, we should see human rights as also taking on environmental issues. And human rights instruments are also seen as living instruments, right? So they need to go along with time. They need to be able to tackle different issues that come their way. And therefore, now the environment and environmental issues should be covered by them. And when we look at air and air quality and what or which human rights or environmental issues should become human rights issue, we should take dignity as a standard, in the sense that anything that connects to dignity or that has influence on whether or not we can have a life in dignity should be taken up by human rights. Because we see human rights sort of as the minimum standard for our life, right? It is the minimum standard for anyone to live a life in dignity. And lastly, we can see that there are definitely some struggles, some competitions going on when it comes to the environment and human rights. One of my previous research is on human right to water. And we can see in that development that the human right to water actually surfaced because there were issues about claiming water, about privatization of water. And that it developed as a human right because it was kind of a counter movement towards the commodification of water. So in that sense, you can see that different struggles and different competitions are coming to the fore also when it relates to the environment, and therefore seeing it as a human right issue or human rights issue can improve access to certain groups, especially vulnerable groups. And lastly, if human rights don't do anything with environmental degradation or environmental issues, human rights might become irrelevant, in the sense that I can see that the future is definitely about the environment and about whether or not we can sustain ourselves here on Earth. So if human rights do not tackle this issue and do not come with some solutions, it might not be an interesting framework anymore, right? So that's why the environment is now more and more becoming a human rights issue, and also we can take that up when we tackle air pollution. So if we want to place air pollution or access to clean air as a right within the human rights framework, there are three different approaches in which we can do that. So the first approach is expanding the interpretation of established rights. So we can look at different rights that we already have, that are already in instruments, and we can see whether or not they have to deal with air pollution, or we can interpret air pollution implicitly under them. So we can look at the right to life, for instance, which also has the general comment, which is no longer a draft. We can look at the European Court for Human Rights, and then we can look at the right to life, but also the right to private life and family life, and we can look at the right to housing. So these three rights all relate to air, and I will expand a little bit in a minute. We can also take new rights, or make new rights, so to speak, and make them as independent, self-standing rights. An example of this is the human right to water, which was seen or is seen as a self-standing right, even though it is not in the instruments, even though it's not in the International Covenant on Economic and Social Rights explicitly, but we can implicitly read it into it. And the committee has then interpreted it as an independent right. And that means that it's not subordinate to anything, it is self-standing. but also the right to a healthy environment. That is something, or a right that has been developing through the years. And we're now seeing whether or not it can be a self-standing right. But I will talk a little bit more about that as well. And lastly, we can look at procedural entitlements. So certain rights that we have when it comes to the procedures that relate to the environment. And of course, we have the Aarhus Convention and the right to environmental information, and also seeing whether or not you can have recourse, a judicial recourse. So let's first look at how we can expand the interpretation of established rights. So the first case that we have, or that is connected to air pollution, is the case at the European Court for Human Rights, and it's against Georgia. And it looks at a thermal power station that was actually located 5 meters away or 4 meters away from the house of the applicants. So the applicants actually discovered that they had certain negative impacts, health issues, and they argued that it was because of this plant, and they argued it under Article 8 of the convention. So that relates to their private life and their family life. What is interesting about this thermal power plant is that there was no regulation. So there were no regulations on how it was supposed to deal with waste, how it was supposed to deal with environmental impact assessments, for instance. This was also logical because at the time, Georgia was not part of the convention when it was built, when the power plant was built. But later on, the court did say that because it has a certain duty towards its residents, it should be able to see that or take into account that these types of power stations have negative effects on residents, and that they should take it into account the moment residents start to complain. So if we look at the case, there are different things that come out. So first one is indeed when it comes to the regulations. So the court argued that there are no regulations. And this is not okay, also not because of the potential risk that is involved. So it argued that there needs to be a fair balance, that states should take into account not only the interest of the power plant, but also of their residents. It also argued that when it comes to the due diligence, that states should take into consideration competing interest, and that they should not take a passive attitude, especially when it comes to these type of air pollutants that have such a bad effect on health. And lastly, they also argued that when it comes to, these type of pollutants, there's sort of, the burden of proof is not that high for the applicants. They can argue that because this power plant is here and we know that pollution, and because they are experiencing certain health effects, that 1 and 1 is 2, and that therefore it is connected. So in that sense, it's a very interesting case because it shows that applicants can sort of easily prove, especially when the health risks are this bad, that there's a connection to certain adverse effects that a plant has. We can also look at the right to life, and here we can look at the general comment that has just been issued. And in this general comment, which is very kind of innovative, we can see that there's also a relation to the environment. So it used to be that the right to life was sort of narrowly interpreted in the sense that it only required negative obligations of states. But more and more, the scope has broadened, and now we also see that they are taking into account positive obligations also in relation to the environment. So if you look at paragraph 30, it talks about how states should take appropriate measures to address general conditions, and that also includes pollution of the environment. And it also talks about how when states take into account the environment, or when they want to look at these serious threats towards the right to life, that they should be taking up measures in line with their international environmental law obligations. So that is kind of bringing together human rights and environment under the right to life. So this is a new development, and I actually didn't think that they would take it this far. There has been, of course, some criticism by states who say that, okay, well, the environment, I don't have that all under control. Why would you link it to the right to life? But I think this is a good development because we see that the right to life is very essential for us, of course. And also because it brings up the question whether or not we can just ask states not to kill us, or that they should also be able to give us an environment in which we can thrive. And what we see now, especially for instance with air pollution, is that slowly we're dying, slowly. So where our life expectancy is being subtracted with 1 year. So it has effect on the right to life, but it is a new way of looking at the right to life and how we can interpret it. So the second approach is developing new independent human rights or environmental human rights. And the first human right in that sense is the human right to a healthy environment. So we can derive that from the right to health. But also in the 1972 Stockholm Declaration, we already saw that it was stated as an independent right. But of course, it's still seen as soft law. We also have the framework principles on the issue of human rights obligations related to the enjoyment of a safe, clean, and healthy, sustainable environment. That is made by John Knox, who is the special rapporteur on this issue. And he has set out these framework principles where he also mentions the right to a healthy environment as a self-standing right. But what is interesting is that even though at international level it might still be soft law, when we look at national level, we can see that a lot of different states around the world have recognized a right to a healthy environment as a constitutional right or as lower law. So you can see that there's sort of a consensus building that the right to a healthy environment should be included and should be a human right. So here you can see, I think for a lot of the states in Europe, it is of course also connected to the Convention on Human Rights, but we can also see that other states have really taken up precedence in that. For instance, South Africa has a very strong right to a healthy environment, and it also even relates to certain boundaries, ecological boundaries that should be taken into account. So in these states, you can see that different states have taken different approaches, but have also connected it to certain issues that they are dealing with. So some states are, for instance, dealing with drought or with some other adverse effects of climate change, and they've taken that into consideration when formulating the human right to a healthy environment. Now, the last approach is by taking up procedural entitlements. So here we look at, for instance, the right to access to information. So this means that we should have access to information about our air quality, what is the standard, where can we see spikes, when can we see spikes, what is the state doing about it. Also the right to participate, so to take into account our needs and our issues when it comes to tackling air quality or air pollution. And lastly, we need to be able to enforce these pollution laws, but also not only against governments, but also against companies. And that is sometimes still a challenge. So with all of this said, we can see these three approaches. We can now see whether or not having a human rights approach to air is beneficial or not. So from my perspective, I would say it can be beneficial in the sense that it should be complementary to the regulations. So now we see that the regulations focus really on the state and on the standards that the state should follow and should implement. And I think that a human rights-based approach should be complementary to that. And I will go a little bit more into that, because it can provide a direct recourse for inhabitants. So right now, you have to go indirectly. So you would have to go to the directive that has a certain standard, and you should hold your state accountable for meeting that standard. But it is an indirect way. So through the human right to clean air, or for instance, the right to a healthy environment that includes clean air, you would be able to directly have recourse for air pollution or in relation to air pollution. What is also interesting for me is that the right to clean air or human rights-based approach would look at the harmful effects. So even though we have these different standards, and we've talked about them a little bit, you can see that there are certain spikes, but what it doesn't do, it doesn't look directly at the harmful effects and how they demonstrate themselves in us as humans. So even though the standard is, for instance, 75, that doesn't mean that if you stay at 60, it is still healthy. So what the human right to clean air could do is actually push beyond those value limits and make sure that people have access to healthy air and not just the basic standard. Because when it comes to human rights, you of course look at individual cases, and for people who are more vulnerable, who actually have more risk or are at higher risk when they have even a little bit of exposure that is below the standard, they will be able to use the human right to air better than, for instance, the standards that's set by legislation. So indeed, we can see that also when it comes to the states, they often have approaches for the nation or for the region, but they don't really look at specific local situations. So if you, as someone, as a resident living in an area that has to deal with a lot of air pollution, the national approach may not positively affect you. And if you're able to use the human right to water or to air in such a way that you can actually have local effect, this can have a benefit, right? And lastly, we have to also look at equity. So how can we make sure that everyone has equal access to clean air? So what we see now is that especially low-income neighborhoods actually have the most air pollution because, of course, the land there is less expensive. It is often in an area where there are lots of roads being constructed. So we can see that we want to be able to target especially vulnerable groups in this sense and make sure that they also have access to clean air because they cannot find any other way to compensate. And this, of course, also brings up the question, where do you put houses? How do you put them there? And what type of adjustments can you make to make sure that people have access to clean air? Now, all of this also brings up other questions, for instance, in relation to climate change. So for climate change, we know that a lot of the pollutants, a lot of the air pollutants actually are related to climate change, but we can see that right now there are different approaches. So we have an approach for climate change when it comes to certain emissions, and we have an approach for air pollution. We don't know exactly how different pollutants relate to climate change, but I think that those two areas should also be more in sync and more combined. What would be interesting in relation to this is this case, which I hope you've heard of, because the Netherlands was very proud of this case, and understandable. But it is a case that relates to climate change. So it's the Urgenda case, where for the first time it was stated that states actually have an independent duty to make sure that the emissions stay low, basically. And it means that the state actually has to take an active approach to go beyond the policy that they already had, and to make sure that even the Netherlands is contributing to not going beyond the 2 degrees. But because that duty was made, or was made present in this case, we can maybe also relate it to pollution and see how the state, when it comes to these emissions, should also take into account air pollution. And then it also brings up the issue of energy. So another colleague of mine who works in Groningen is actually working on the right to energy, because she feels that Access to energy is, of course, related to what type of inefficient transportation we use or not use. So she argues that actually getting access to clean, affordable, sustainable, reliable, and modern energy will help us to realize a healthy environment. This is, of course, also an interesting argument. You can then bring up the question whether or not energy is connected to dignity, because as human rights lawyers, we take dignity as the principle, and anything that relates to that should be covered by human rights, so to speak. So does the right to energy, does it relate to dignity or not? And you can have an interesting debate about that as well. And lastly, what I think is interesting is also the place that science takes in this debate around pollution, and who's the expert on science. Because what you see now is that a lot of different programs around citizen science, so where citizens or inhabitants of a city actually take up certain air quality, pollution measurements, where they communicate about that, where they make apps about that, and where they share information about air pollution. And this, of course, also then relates to public litigation, public interest litigation. So how do we connect those two? Can we use, for instance, evidence that was made or gained through citizen science as a way to argue your case in court? Because that is, of course, also very interesting for parents who indeed see that their children are going to schools where the air pollution is really bad. Can you measure it there and then use it as an argument in court or not? So I think that will be also an interesting development. And here we can see the website of the EPA, which is still working, even though things disappear all the time under the current administration. But they have a citizen science website still, where you can get certain information about how to collect data. And even in France and Belgium, different citizen science projects are underway, also funded by the European Commission, to make sure that people have access to information and that they can share it, and make sure that they also take certain responsibility when it comes to dealing with air pollution. Because that is, of course, also a question when it comes to air pollution is what is our own responsibility? So can we argue that we should no longer drive cars? Can we argue that maybe I should open my window on the back side of my house? How do I deal with it myself? Do I make sure that my garden is fully green to make sure that there's some compensation? And of course, you don't want it to go to the extent that people cannot live in certain areas, or that insurance take that into account, or other type of issues. So in that sense, when it comes to air pollution and environmental pollution, we have this issue of how do we balance also personal responsibility towards state responsibility. And lastly, we're back to this issue. And we started off with Ella, so I'm also ending with Ella. We now see that this issue has to do with the right to life, because unfortunately in this situation, she has already passed, so we cannot argue this under the right to family life. But I hope that this case will be the first case that can actually show that people do have a right to clean air, and that hopefully we can prevent more children from dying. Thank you.